The Florida Supreme Court prevents the state from becoming a mishmash of gun laws. Welcome to another installment of the Connecticut and Bitch. Today's video is brought to you by P.A.N. Firearms, LLC, P.A.N. Firearms for NRA certification and multifaceted gun training. You can reach us at 203-300-6343 or use our website at www.panfirearmsllc.com. As always, there'll be a link in the description box below. And let's talk about this. Now, state of Florida, a lawsuit was filed by 33 counties, if I'm not mistaken. And what they were arguing was the state has a law that says if you enact gun control that exceeds the state's limits, they can fine you monetarily for doing so. And a number of these places were filing suit because of what happened at Parkland. They were trying to pass gun control laws that were above what the state laws require, and they took this argument to court, saying that these monetary fines were unconstitutional. And the Florida Supreme Court, in a decision, I believe it was 5-1 ruling, said, no, this is perfectly fine. But what they have basically done is prevented counties or cities, like you see, like in Illinois, from enacting gun control laws, like an assault weapons ban, where the state doesn't have an assault weapons ban, but a county, like DeKalb or one of the counties, has an assault weapons ban. That's what they're preventing from happening, and that's what these counties want in response to what happened at Parkland. Obviously, you can figure out that these counties that are doing it, so these areas are all run by Democrats. But I'm going to jump into this. This is the Miami Herald. And the Florida Supreme Court rejects post-Parkland challenge of state gun law. In a case stemming from the 2018 mass shooting at Marjorie Stoneman Douglas High School, the Florida Supreme Court on Thursday rejected a challenge to a state law that threatens stiff penalties if local officials pass gun-related regulations. The 5-1 ruling was a blow to 33 cities. Okay, so it's 33 cities and counties and dozens of local officials who contended that penalties in the 2011 law were unconstitutional. It was a victory for state Republican leaders and Second Amendment advocates such as the National Rifle Association. Florida, since 1987, has barred cities and counties from passing regulations that are stricter than state firearms laws. And the penalties in the 2011 law were designed to strengthen that preemption. The law, for example, could lead to local officials facing $5,000 in fines for passing gun regulations and would allow members of the public and organizations to receive damages and attorney fees if they successfully sue local governments for improper gun regulations. Basically, if a city passed a gun regulation that was outside the scope of the state law, the groups within that city can then turn right around and sue them for doing so and get monetary damages. But the case did not challenge the underlying 1987 law, but contended the penalties in the 2011 law were unconstitutional, in part because they violated legal immunities for local officials and governments. Also, attorneys for the cities and counties argued the 2011 law violated the constitutional separation of powers because it would lead to courts delving into the motivations or intentions of local elected officials. Well, we know that when these people pass, like, let's just stay on a common subject, when they pass an assault weapons ban, well, that's very, very singular. That's very focused. They're not doing it for the safety of the public. They're doing it because it's the cliche thing to do at this point in time. So this basically says, well, if a judge is looking at it, go, oh, you did this because you were motivated by bias, and they're afraid that would happen with this 2011 law. But Justice Ricky Polston, in Thursday's 25-page majority opinion, rejected the arguments, including that the law violated what is known as governmental function immunity, a legal doctrine that helps shield government bodies from liability. Quote, the imposition of these civil statutory actions for violations of the 1987 preemption statute does not violate governmental function immunity, Polston wrote. It is not a core municipal function to occupy an area that the legislature has preempted, and local governments have no lawful discretion or authority to enact ordinances that violate state preemption. Polston was joined in this opinion by, I guess, 5 other judges. Don't need to get into that. Of course, there's one that dissented, and for the sake of fairness, Justice Labarga dissenting opinion. In his dissent, Labarga argued that the 2011 law violated the separation of powers because it would empower judges to determine whether violations by local elected officials were knowing and willful. Quote, the requirement of judicial involvement in determining whether the actions of the public official was knowing and willful amounts to nothing less than an impermissible judicial intrusion into the official's legislative thought process, and it undermines the official's ability to effectuate the constituents' will, Labarga wrote. Well, that's a very interesting, and it sounds like, once again, this is a biased leftist judge, and that's fine. Okay. And then, so you've got the idea there. Okay, so I'm going to come out of this. So, the Florida Supreme Court basically prevented cities, in a sense, prevented them from enacting laws within a certain boundary, like a city or a county. Okay, because this threat of monetary fines is keeping them from enacting gun laws that go above and beyond the state law. This is a positive win, and hopefully, if it's going to be pushed up to the next level, I doubt they will try. They might. Don't know. If it pushes up to the next level, this is already Florida Supreme Court, so it's going to the Supreme Court. Once again, hopefully it will set a precedent where counties and cities cannot make gun laws that are above and beyond what the state laws are. That's a very positive thing. If you remember, I did a video on Colorado where they basically opened the door for such a thing, where each county could make their own laws that were stricter than the state law. They couldn't make laws that were not as strict, but they could make them stricter within the county. So they basically chopped up Colorado into a really nightmare for gun owners, from going from one county to the next. Am I legal going from here to here with my firearm? But we'll see how this plays out. But let me know what you think. As always, you can leave your comments in the comment section below. And as always, any statements of violence or statements that lead to violence will be removed. Please like, share, comment, subscribe. Don't forget to hit that notification bell so you're notified the next time a video goes live. I'll see you on the next one. Peace.